Salutations, respected viewers. I'm George from Ireland. This is my English law channel. So this is another video about contract law, and the subtopic now is the discharge of contracts. From this area of law, you might get the impression that every contract is breached. There's always rescission, or it's always declared void, or something like that. But that would be misleading. Quite often they end properly. There's satisfactory performance. Both parties are happy, and it ends that way. It's been completed. Anyway, so it can end through performance. That's the most common one. The contract is carried out, and it ends. Everybody's happy. It could be end by agreement. Both parties partway through decide, okay, we'll just end this contract and we'll release each other from these mutual obligations. Or it could be breach. If there's breach of contract and one of the parties elects to go for rescission rather than affirming the contract. There's also frustration, but I think I won't come on to that today. So, discharge by performance. That is when all the obligations are fulfilled. So in some cases, there's an entire obligation clause, as in you don't get any money or you don't get whatever is the consideration on the other side unless you fulfill all your obligations in their entirety. The leading case for this is Kathryn Powell in 1795, or should that be Powell? Powell. Some people pronounce it Powell. So there was a merchant seaman, and he was contracted to sail from Jamaica to Liverpool, and he was going to be paid 10 days after docking at Merseyside. However, a few days before they made landfall in the United Kingdom, he died on shipboard. So the ship docked in Liverpool, and the captain had to break the news to the man's wife that her spouse was deceased. Well, obviously she's in mourning, wearing her widow's weeds, but by the way, please could I have his salary? And they said, no, you're not going to get a salary. Well, she said, okay, we didn't quite complete the voyage, but he completed 9/10 of it or whatever. Could I have the money for that? And they said, no, you shan't get a brass farthing. It was an entire obligation clause. Unless he completed the voyage, you didn't get a penny. And the court upheld that. It seems incredibly unfair, but that was the rule at the time. I mean, I don't see why they didn't regard it as frustration. He couldn't carry on because he was dead. There was non-existence of the subject matter in that sense, as in him. Well, that would seem like voiding it. But anyway, so how about mitigation? Let's reduce the harshness of this situation, of the entire obligations clauses situation. Sometimes one can accept part performance, sumpter against hedges. Sometimes there's substantial performance where we've performed most of it. Honier and Isaacs, 1952. Well, there's a case about it called Bolton and Mahadeva in 1972. Sometimes the entire obligation can be divided into a series of smaller obligations, the totality of which is the entire obligation. So divisible obligations as per Rose and Frank against Crompton Brothers, 1923. So you can get paid on a quantum meruit basis, as in as much as he deserves. Now, sometimes a third party can perform part of the contract. So this duty to perform part of the contract is actually carried out by a third party. British Wagon Company and Lee, 1880 is an example of that. Now, sometimes this obligation is a personal service, as in only you can carry it out. If a third party carries out that bit of the contract for you, it doesn't count. That's as per Robson against Drummond, 1831. Because sometimes it matters who does it. It doesn't matter that the service itself is done. It's got to be done by the right person. So sometimes a contract can be discharged because both sides agree to that. It can be a condition subsequent on the occurrence of various obligations which are carried out or discharged. That's as per Head against Tattersall, 1871. Now, you can agree to terminate rights, and they both choose to get out of the contract. So this mutuality of consideration is ended. So they might say what the notice period is going to be. Sometimes there's a minimum time period. You have to go on at least a month into the contract, have to give us at least a week's notice or something like that. It could be the contract is discharged if certain events occur that they've agreed in advance. They might agree if there's been some sort of breach that is a material breach and not an immaterial one. So you've got to see if what's provided for. It's not all these things are set out in contracts. Now, it's often held to be an implied term that a contract can be rescinded if you give a reasonable notice. Now, what's reasonable? How many days or weeks? obviously depends on the nature of the contract, its duration, whatever that was. Its duration was sometimes envisaged. You might even spell it out. This contract's to last for 3 years, and so it's a relatively long contract. You'd require a longer notice period. If the contract's to be all performed in 1 day, the notice period might be quite short. Okay, so both parties, even if they didn't envision ending it in some way, they could at some point both agree to bring the contract to a close and release each other from their exchanged obligations. This terminating the contract is often backed up by consideration. I'll pay you this much to be allowed out of it, things like that. Like, let's say, renting a house together, and one of the lessees wants to get out of it. The other say, okay, you can, and we'll pay the rent until we find someone to exchange to take over that for you, on condition that you leave by a certain date, something like that. That's the consideration the party who's leaving this contract to rent the apartment together would give, and the other parties are saying, and we're taking over your rent obligations until such time as we can replace you. That's the consideration those parties are giving the parties who are remaining behind in the apartment. So, okay, so sometimes they're executory contracts. So the obligations on both parties require mutual waiver. Remember, executory contracts is simply an exchange of promises. Nothing's been done yet. Nothing's been paid. No goods have been provided. No services have been provided. The Hannah Blumenthal 1983 is a case of that. Sometimes a contract has been partly performed, so the contract could be discharged by deed, as in a special legal document, which is signed by accord and satisfaction, which is another form of agreement, as in Pinnell's case 1602. So how about when it's breached? Well, what is breach of contract? Tritel was the judge who famously gave the following definition: where a party without lawful excuse fails or refuses to perform what is due from him under contract, or performs defectively or incapacitates himself from performing. Close quotation. So, for example, he's a builder, he's meant to do a big building job, but he takes on another building job before he begins the one under the contract we're thinking about, and therefore he just won't have time, won't be able to do the building job that we contracted him to do. Or you agreed to provide whatever item, you sold out all your stock of it, therefore you're not going to have any left that we need in time, things like that. Or you were meant to turn up sober to sing your bit at the opera house, you got yourself blind drunk, so the time to sing actually hasn't come, but we know you've rendered yourself unable to perform, things like that. Or you have carried out the contract but done it so badly, you're meant to clean the house, but you've done a real half-assed job and the house is scarcely clean, so that would be a case of performing defectively, things like that. All right, so how can you terminate for breach? So this is common law. Sometimes there's a repudiatory breach. So you've just done something which makes it impossible for you to carry it out of the contract. So there could be clauses there saying what's going to happen in the case of termination. So repudiatory breach, there's a renunciation here. So the person has shown an intention to give up the contract, not to perform it, or certainly not to perform it properly. That is as per Eminence Property Developments Limited against Heaney, 2010. The other way, there could be this repudiatory breach if someone is in breach of a condition, which is clearly, definitely a condition, or an innominate term, which is so important that it must be regarded as being equivalent to a condition. Remember, that's as per the Hong Kong fur shipping case that invented innominate terms. Remember, if there's a breach of warranty that only leads to damages, you do not have the right to rescind for breach of a warranty. So what is a condition? Well, a condition could be something which is said to be conditioned by statute, or the parties have defined as a condition, or a previous court ruling has held that is the condition. Conditions go to the heart of the contract. There's something crucial to it, as in what the subject matter is, what items are to be sold, or what service is to be performed, or indeed what money is to be paid, or the things that you're not supposed to do in a non-disclosure agreement, the information you're not allowed to disclose, or the non-competition clause that you're not allowed to set up a certain business within a certain radius, within a certain time frame, something vital like that. So because the whole thing is conditional upon that term, the whole contract. So these are things which, as they say, go to the heart of the contract, as per Poussard against Spears. So innominate terms, they are regarded as being as important as a condition because of the consequences that flow. some innominate terms, because of the consequences that flow, are held to equate to a warranty. It depends on the repercussions of the breach of that innominate term. And sometimes we can't tell what the consequences are going to be until the breach occurs. Okay, so discharge by breach. Remember the Hong Kong fur test. Does this breach deprive the party of substantially the whole benefit of the contract? That's what the judge said. The test is, that's what I ask. So it doesn't have to be absolutely the whole, but more than half of it has to be just impossible to perform, or performed very defectively. So this is quite a high bar to clear. Deliberately is set that way. So Telford Homes Creekside Limited and Ampurius NU Homes Holdings Limited 2013 is a case in point. Now there's also anticipatory breach. Well, that's what I was talking about before, really. It's you anticipate that the other side is going to be unable to perform. Now, it could be the other side that says, I'm just not going to be able to carry out, or I've got no intention of fulfilling my obligations, certainly not properly. Hochter against de la Tour in 1853 is that case. So remember, if it's an anticipatory breach, it must still be repudiatory. So what happens when there's a repudiatory breach? What's the process, and what are the consequences? You have to decide that the right of election. That means the repudiatory breach does not mean there's automatic discharge. The innocent party must say, I am declaring this breached. Okay, you have to actually say it, so they can terminate the contract. The parties can be discharged from performing any more. The rest of the contract is not to be performed. However, the rights that they've already gained remain there, because the contract doesn't have a future, but it does have a past. So you can claim loss of bargain damages because of the whole contract. You expected a certain profit, you've only got a bit of that. You're allowed to keep that, but what about the profit that you've missed out on? You can get damages for that. Or if there's this serious breach, nevertheless, the injured party could affirm the contract, say, yes, let's continue with performance, so they no longer have the right to terminate if they've affirmed it. So you can get some damages, but these are only the losses which are directly attributable to the breach. So you've got to be careful. If the other side has committed a serious breach, are you going to affirm or are you going to terminate? Because you can't change your mind. Okay, so anyway, more about repudiatory breach. You have to notify if you're choosing to terminate, or indeed you can accept the breach by notice or by your behaviour. If you just carry on performing as though nothing had happened, that's clearly you affirming to accept going on with the contract despite the breach. Vitol against Norelf, the Santa Clara 1996 is a case of that. So it was held here by Lord Justice Asquith in Howard against Pickford, Toole, 1951. An unaccepted breach is a thing writ in water. Seems to be quoting John Keats there on his gravestone. Here lies one whose name is writ in water. I think it's meant to be ephemeral. So you've got to act quickly if you're going to be able to terminate. So if you reject things, well, there's another remedy in the terms of sale of goods. Okay, so damages and repudiatory breach. You could terminate claiming repudiatory breach, then you get damages for the lost performance of the whole contract. Or indeed you affirm the contract despite the breach and you will get damages, but these are more limited, and these were the only ones which you can prove are directly connected to the breach. So, and there is a limit of remoteness. If things are too remote, they're too indirect, you won't get those damages. And remember, you have a duty to mitigate. If you carry on performing on a full scale, which is therefore increasing your losses, you're not going to get damages for avoidable losses. It's up to you to keep the losses down. Okay, so they're various things. To carry on with. Anyway, if you can have an agreed termination clause, certain events will be regarded as a breach event, and this will permit parties to terminate the contract. The breach has to be material. It can't be trifling. It's got to be beyond the de minimis range. Anyway, sometimes the breach is irremediable. It can't be put back. It can't be bettered. So therefore, if it's very small, it's remediable, then the party in breach might be able to remedy that, and then the contract could carry on as originally envisaged. So if you fail to remedy your breach within a set period, you could say 3 days or whatever, after being notified by the innocent party, you've got to sort this out, then the innocent party could well have the right to breach. So contracts can set out, these are the conditions, this will lead to breach, we'll have to give you so much warning if we think you're in breach. Okay, so agreed termination clauses therefore make the standard rather lower than in Hong Kong fur. So it's an easier bar to clear. So parties will have the option to leave the agreement if a certain eventuality comes to pass. So you'll still have the right to damages arising from the breach, but you won't have the right to damages for loss of performance of the whole contract, unless, of course, it was a repudiatory breach. So there is still danger. Watch out for wrongful termination. If you're going to terminate, the onus is on you to prove that a breach occurred, that a breach was material, and so on, and that you communicated your desire to terminate. But if you're wrong, if there was no breach, or there was a breach that was immaterial, or you didn't communicate it, things like that, it wasn't a breach of a condition, it wasn't a breach of a sufficiently important innominate term, then you could be in big trouble. Okay, this could lead to renunciation. So the terminating party might have to deal with a claim for repudiatory breach and damages for loss of performance of the whole. Okay, as in you're going to buy some goods, you said you're in breach, so we're not going to buy them. Well, you might, if your declaration of breach was erroneous, you might still find yourself paying for them. Okay, so if there is a breach, you could nevertheless affirm the contract, say, all right, we accept, we want to carry on, and you could do this in express manner, as in actually saying it, or you could do it inadvertently. Also, estoppel operates here. There's acceptance of a breach as per the Sale of Goods Act. Could be lapse of time. There's a breach, you know about it, you did nothing, and you can't come back to it months or years later. You have to act swiftly. However, the innocent party is allowed some time to decide. You don't have to decide instantaneously, as per Stocina, Gdanska, and Latvian Shipping number 2, 2002. Remember, if you do want to continue, it must be clear and equivocal. Those were the words used by a judge, clear and equivocal, in your expression of a desire to carry on with the contract, as per Yukon Line and Rendsburg Investments 1996. So if a party says yes to the contract and carries on, obligations and rights remain for both parties, as per White and Carter against McGregor 1962. Why do some people say yes to continuing the contract? Why do they affirm it when they know there's been a breach? Well, they don't want to deal with the other party saying, no, that was not a proper breach and you can't terminate now. Sometimes they still want the contract carried out. There's some benefit to them. They think the breach is not important enough. It's more maybe a hassle to find an alternative provider or supplier. Suing for damages is a risky business. It's long, it's expensive, it's maybe even embarrassing, it might damage their reputation. So you have some termination right. You have some leverage over the other party who might offer you some consideration not to terminate. Okay, so you could get a better deal. So suppliers, why do they often affirm? Well, because there's a distinction between debt and damages. Debt, that's a liquidated amount of damages payable according to a term of the contract, whereas damages can well be unliquidated, and we don't know how much they're going to be, and they are subject to various conditions. Proof that the breach did indeed occur, it was material and all the rest of it, that it was either a condition or a sufficiently important to nominate term, that mitigation was used, that you actually tried to keep your losses down, and lastly, all the limit of remoteness. If losses are too remote, they shan't be recoverable. So suppliers often affirm. Suppliers often carry out their services and they issue invoices for goods. They claim in debt and they don't claim in damages because therefore things are sure. There's no limit of mitigation here. They don't have to deal with the rules of remoteness. There's an issue of circumventing exclusion clauses, and there are some strategic advantages if it comes to litigation, i.e. legal negotiation. So anyway, there are some risks to affirmation as well, of course. The affirming party might find himself declared to be in breach, as in the Simona 1989. A subsequent frustrating event might mean that there's no right to damages, as in Novus Actus Interveniens. Avery and Bowden is a case of that. And again, there were restrictions on your right to affirm. you mustn't be dependent on the other party cooperating, as in Hounslow against Twickenham Garden Developments, 1971, to do with this London Borough Council, that they could only perform the contract with the other parties helping them. So if it's contingent on the other party's assistance, then you obviously can't perform the contract. So there's no sense in affirming. And there also must be a legitimate interest in performing. That's what Lord Reed said in White and Carter against McGregor. You can't do it out of sheer perversity. Okay, what's a legitimate interest? It's where affirmation is not wholly unreasonable, as one judge said in Clear Shipping against Bulk Oil. There's a case known as the Alaskan Trader, 1984. The legitimate interests are only applicable in extreme cases. This is where the damages wouldn't be satisfactory as a remedy, or affirmation is regarded as unreasonable. That's as per Ocean Marine Navigation against Koch Carbon, the Dynamic, 2003. So a landlord will be deemed to have a legitimate interest in affirming a lease. That was decided in Reichman and Beveridge in 2006. Well, that's enough about this particular subtopic of law, discharge. Next time we'll look at frustration. Bye.